If you look at the invoice, wouldn't it be fair to say that he told you that the sale was as is, that he made no guarantees about the authenticity or the genuineness of the cards?
This is what I thought the whole case was going to be on, because this really, to me, all that matters. This would be where he could have a point.
I'm here.
As is to me.
I'm here.
Let me finish.
No, I'm not going to let you finish. You let me finish.
Go for it.
I'm here to give you an opportunity to explain your basis for suing this man.
Okay.
How is he liable given this statement?
Well, I looked up and I read the law, and it said if he knew or didn't know, and I'll give him the benefit of the doubt that he didn't know, that if you buy counterfeit cards, the seller the sale would be reverted.
Can you cite that particular section of the law to me?
I would think you guys know it.
Yeah, well, we know so much, and sometimes it's difficult. We can overlook certain areas.
And second of all, if I sold cards to someone and they were fake, why would I keep their money? Why would I keep their money?
I didn't keep it. We had to give that to the client.
You don't have to answer him.
Sorry.
You answer me.
And second of all...
Okay, and that's enough.
Why?
That's enough. I didn't ask
There's
you
some
anymore.
interesting stuff there.
I will give you an opportunity to express yourself a little bit later. So you claim that your understanding of the law is if I sell you something that's counterfeit, that I am responsible for that, despite the fact that I make no representations about the authenticity of the item.
But if he did know, which I'm starting to think he did, because guess what? There's a third card that was fake. I discovered this, a third card. So I think he might have known, and that's criminal.
Were you aware that these cards were suspect in any way?
No, sir.
So when you had these cards in your possession, had you paid for them?
No.
You were going to give the owners of the cards the profits,
the beneficiaries,
less your 35% of the profit.
So after this, the sale usually lasts about 7 days. Then we take our percentage and we give the remaining to the client, or the beneficiary who owns the items.
So are you saying that you would have to come out of your own pocket
if I were to have to pay him back,
return that value? And you were, isn't it true, gambling that these would be the cards that you thought they were?
Maybe I was, sure. I'll give you that.
So who should bear the risk of your gamble when the defendant gave you every opportunity to check these cards out?
I'm going to tell you that his case is fine, except all these lies. I wasn't even going to do it. You know what? I would eat the money. He is such a jerk and lied so many times.
No, I'm not going to let you call anybody a jerk in my courtroom.
That's fine.
So that's why I'm here. Each other?
Especially him.
Decency.
I've heard enough.
Yeah.
Parties are excused while we deliberate in this matter.
All right, Mr. Carlin, Mr. Ivankic, we have come to a unanimous verdict. One thing that stood out for me, Mr. Carlin, that you said early on was, I was willing to take the risk. And this sale wasn't a pressured sale. You had ample opportunity to do your research, to speak to a number of experts in card collecting, and you decided to still go with the sale. And in the invoice stated no refunds would be allowed, cards are not guaranteed, this is an as-is sale. And that doesn't necessarily mean that it's always the case when you are signing off on a sale that's as-is. But we have no proof today that the defendant knew these cards were fakes and tried to trick you. In fact, he knew very little about cards. You knew more about cards than the defendant. And for that reason, we have unanimously found that your burden of proof has not been met today, and we have to dismiss your case.
Done.
All right, good luck to the both of you.